is January 27th, and this is Senate Judiciary and Public Safety Committee. Today's meeting, the agenda will include an overview of Minnesota's probation delivery system. We'll be starting out with that report by Ms. Carly Stark, and then moving on to other guests that will be adding to the report, and then an overview by the Minnesota Department of Human Rights. So, Ms. Stark, if you're there, we can begin with you.
Thank you, Chair Limmer. Let me just share my screen.
And could you identify yourself for the record before you proceed?
Yes. Well, first, hello. I am Carly Stark. I am the Public Safety Policy Analyst with the Association of Minnesota Counties. I am also the Executive Director of the Minnesota Association of Community Corrections Act Counties, which from now on I will just call MACAC. And thank you, Chair, for letting us come give this presentation.
All right, please proceed.
All right, well, let's see. First, I'm just going to talk a little bit about counties in general. Minnesota has 87 counties and 447 county commissioners. 81 county boards have 5 county commissioners, and 6 boards have 7 county commissioners. County budgets range from $6.75 million at the low end to $1.9 billion at the high end. So as you can see, there are very differences in county budget resources. So the Association of Minnesota County is a voluntary association of Minnesota's 87 counties, and it has been around since 1909. We try to be the voice of county government in Minnesota and to the legislature. We also provide education, training, research resources for counties and county officials. In addition to counties, we also have 20 affiliate members, which are associations that support specific county functions, like MACAC, who is made up of probation directors. We have the Minnesota Engineers Association, the Minnesota Association of Workforce Boards. So any specialty county work, there's probably an association for it. So our mission is to unite Minnesota's counties to achieve public service excellence. And our vision is that Minnesota counties are trusted partners in strengthening communities. So when you are asking questions about how things work in your own county or counties in your district, if you need county-specific data, if you need to find out what communities in your district think about specific policy provisions, you may want to engage counties. You can either reach out directly to your commissioners or your county staff, such as community supervision directors or emergency managers, or you can contact AMC for more general questions. We have policy committees for all different topics, such as public safety, and we have AMC staff that are policy analysts for different issues as well. So now on to the probation delivery systems. As you may know, Minnesota relies heavily on community supervision. At some point, people started to realize that, you can send people to prison, but if you don't provide any kinds of services or teach them how to live full lives in the community, they're just going to get back out and keep doing the same thing. So Minnesota as a state decided community supervision is where the real work to change behavior happens, and placed resources into that system. So when I'm talking about supervision, I'll generally be talking about probation or supervised release. Probation is after someone has been convicted, they are given a stayed prison sentence and basically told, if you complete your probation successfully, you will not go to prison and you can stay in the community. And then once that is complete, you have served your time on probation. The other thing I will talk about, what I mean by supervision, is supervised release, which is a period of supervision after someone has served their criminal sentence. A lot of people say parole, but in Minnesota, we call it supervised release. Generally in Minnesota, people spend, if they're sentenced to prison, they spend 2/3 of their sentence in prison and 1/3 on supervised release. What I won't talk much about is intensive supervised release, which is for some more serious crimes and is handled by the state. Occasionally they give grants to counties to do it, but I'm not going to talk too much about that. The other thing I won't cover much is pretrial supervision, which is supervision that's prior to a criminal conviction. So as you can see from the slide, there are approximately 103,000 adult and juvenile clients on supervision statewide. 6,882 clients are on supervised release. They are spread throughout the 3 delivery systems, but the delivery systems that are run by counties supervise 83% of individuals on probation and supervised release, and the Department of Corrections supervises 17% of those individuals. I'm going to give you just a very brief rundown of the 3 systems, and then I will go into more detail about each one. So Community Corrections Act supervises the most individuals, which is about 71% of the probation and supervised released cases. Generally, the way the Minnesota statutes were set up is that the state was responsible for felons or felony cases, and the counties were responsible for misdemeanors, gross misdemeanors, and juvenile cases. In 1973, there was the Community Corrections Act, which allowed the state to basically delegate their authority to do felonies to the counties. So people who choose to be a counties that choose to go Community Corrections Act, they do all of the supervision in their county. So the state doesn't do any of it. Now, there are also Department of Corrections contract counties, which is about 17% of the probation and supervised release cases. That is where a county says, you know, we don't have the resources to do the supervision in our own county. So DOC, we're going to make a contract with you and pay you to do all of the supervision. And then there's a third kind, which is like a hybrid, where the counties do some pretrial felony services, but mostly misdemeanor, gross misdemeanor, and juvenile. But then the state continues to do the felony supervision. And that makes up about 11% of the different cases. It's important to understand the difference, because though some of you, such as Chair Limmer and Senator Latz, you only have one delivery system in your district. Senator Matthews, you have all three types in your district. Senator Johnson and perhaps Senator Ingebrigtsen as well, you have 2 types of delivery systems. And then Senator Bigham, despite having multiple counties, you only have 1. So like I said, it's important to understand all 3. Here is a map of the different counties. This is as of July of 2021. There are 2 counties switching delivery systems. So this is a little different than how it currently is, but as of July 1st, this is the way it will be. So I'll start with DOC field services. As I said, there is a kind of system, which is DOC contract. That's 29 counties where the DOC provides the misdemeanor, gross misdemeanor, and juvenile supervision, as well as felony supervision. And then in 24 counties, the counties do the lower level offenses and juveniles, and then the DOC does the felonies. And I will make a note that the 82 counties for the CIP, which is Challenge Incarceration Program Supervision, that may not be a correct number, but if you have questions about that program, they are better sent to the DOC, because counties generally don't do that. So in DOC counties, the way it is funded is the counties are billed for those lower level offense supervision, but then they are reimbursed a portion of those costs depending on how much money is appropriated from the legislature to the CPO reimbursement. The felony supervision, the county doesn't have to pay for any of it because it is the state's responsibility. So the county only pays for the lower level and juvenile supervision. So the next model is county probation officer. And as you may remember, that's that hybrid model. I believe it started in the 50s, the statute 244.19. So the county supervised juvenile, adult misdemeanor, and adult gross misdemeanor offenders. They are employed by the county, but are under the supervision of the local judge. Now that's changed a little bit in recent years, but really the judge in those counties has the authority to appoint the director and hire staff. It's turned into more of a partnership based on some judicial policies. There are 24 counties organized as CPO. There will be 23 because Nicollet is changing over to Community Corrections Act. So funding in those counties is where the DOC pays for all the felonies, and then the counties pay for the lower level crimes, or the supervision of those individuals. There is a statute that requires that the state reimburse certain employee compensation for the counties at 50% reimbursement. And it does say shall in the statute. However, there's also a provision that says the funding is to be determined by the legislature. So if the legislature does not appropriate enough funding to get to that 50%, then the DOC only has to reimburse what they have the money for. Currently, the state funds cover roughly 29% of costs for those reimbursable expenses. So and again, felony supervision is paid for by the state. So Community Corrections Act, that is, as you will recall from just a minute ago, where the county does all of the supervision. And they also do supervised release. There are 34 counties organized into 21 jurisdictions that participate in the CCA. A county must have a population of at least 30,000 people or be part of a joint powers that reaches that threshold in order to participate to CCA. The funding in CCA counties is kind of like CPO in that it's a mix of state and county funds, but it's a little bit different. So the CCA counties get a subsidy from the federal government, or not federal, I apologize, from the state government. So as I mentioned, felony supervision is a state responsibility. So in CCA, they're saying we're delegating this responsibility to you, counties, and for that, we are going to give you some money. The money, there's a hold harmless amount that every county gets no matter what, but then there's a part of that subsidy that's determined by the legislature and is distributed based on on a formula that considers case filings, population, felons who are convicted but not sent to prison, and adjusted net tax capacity. So basically that means it considers, case filings, population, and the county's ability to pay, because we know that some counties have a very low property tax levy and just don't have the ability to put as much money into the system. So that's where a big part of the state funding comes from. The other funding comes from the county. So as you can imagine, the intention of the legislation was that it would be somewhat of a 50-50 cost share, though there's no straight percentage defined in statute. So who decides which system? The county board decides. They have considerations like, do they want to control how probation is done in their county? How much do they want to pay? And other factors like that. It's always important to ask judges, county attorneys, and other stakeholders for their input, because despite the siloed funding of public safety, it is one public safety system. In order to stay whatever system you're in, there's no board action required, but if a county wants to transition to a different model, they have to make that decision in July of an even year and then transition the next year. And that's because of the biennial budgets. So despite the fact that there are 3 delivery systems, all 3 follow evidence-based practices, which basically means, they look at the evidence and then they base their practices on that, which is, it's shifted over the years because probation used to be about checking court conditions off, like make sure that people aren't violating court conditions. And it shifted a lot to try and ensure that services are being provided that actually change behavior and help people be a better part of the community. They use risk, need, and responsivity principles, which means you look at the risk of people and make sure resources are going to those people with higher risk of recidivating. But you also look at what each individual needs. So you want to target their specific needs, because if you don't, you'll have worse outcomes. And responsivity is kind of like, so that's making sure that you consider how people respond to certain interventions. For example, in certain cultures, looking someone in the eyes, a superior in their eyes, is not something that you do. So the probation officer has to know that about the person, to know that if they're looking down, it means they respect you, as opposed to they're just not focusing on their treatment. Anyhow, despite the fact that we are constantly in competition for funding, the delivery systems do work together to create change in the state. So Chair Limmer asked that I touch on some of the impacts that COVID has had on the county-based probation systems. So the very first thing everyone had to do was address and overcome financial and technology challenges. Nobody was set up for virtual work, which is basically the same in all county departments. So after scrambling to get that set up, there were many months where there were PPE shortages. There has been a huge reduction in jail intakes and in warrants being issued by the courts, which means that people are staying in the community and on probation a lot more. And it's difficult, it has been difficult to do any kinds of sanctions or try and hold people accountable with like a day or 2 in jail. Granted, there are other ways to do that, which I will get to in a minute. There is a huge delay in the court process, which means there's a huge backlog of cases. And I believe you heard from the judicial branch about that, which means if counties are not seeing increased caseloads, they probably will once all of these backlogs are gone through. Because of the uncertainty with the judicial backlogs, it's been very difficult for counties to plan their budgets, which I assume is the same at the state level and pretty much across the country right now, because we're all just going from budget forecast to budget forecasting what's going to happen. Counties have implemented alternative methods for meetings, doing virtual meetings, meeting in public parks. I don't know how that's going this winter, but I know in the summer there were a lot of meetings in parks. They will go to clients' homes and talk on the phone, but be able to see them through the window. They've really been focusing on how to provide effective interventions while not seeing people in person. Despite the fact that a lot of counties like that there's a virtual option because of the problems with transportation and childcare and things like that, they know that there will always be a place for in-person visits, because it's hard to create a relationship between the probation agent and the client. And that's critical for success, because that personal relationship is what helps the client feel supported and encouraged to make change. One thing that has happened was there are virtual COG groups, which are basically cognitive behavioral interventions. So it's behavior change groups, basically. They've done more targeted drug testing. A lot of drug testing centers were closed for a long time, so they had to be a lot more specific about who got drug tests. The jail population has gone down, and there's been an increased use of electronic home monitoring. The things that I've heard around the state that people think have worked well, and granted, this is not the same for every county, but having virtual groups and virtual meetings has been very helpful because a lot of clients have transportation issues, especially in greater Minnesota. So they can't always get to the probation office. And as I said, this isn't something that is going to be forever, but it's always nice to have that option in case there is a transportation issue so that the agent can still do the work with the client. Some treatment providers have also had virtual meetings. And then a lot of counties want to make some sort of virtual meetings part of their permanent work, allow a little bit more teleworking from employees, continue to have virtual communications, expand alternatives to jail sanctions. One thing that has been interesting is because there aren't as many warrants or court hearings, agents have to be very creative in order to make sure that their clients are held accountable. So they'll be creative with sanctions to try and keep people on track. Far and away, the biggest thing people really want to see continue is remote court hearings for uncontested cases. So I'm not talking about contested violations or revocation hearings. I'm talking about, like, occasionally a client will come in, they had a violation, and they will say, you know what, I did that. I agree with the restructuring, and you just need to get in front of a judge. Things like that have helped. Doing them virtually has helped clients a lot not clients. It's probably helped them too because of transportation things, but it helps agents because instead of being at the courthouse for 3 hours, they can sit and be doing their work and then have their Zoom screen off to the side waiting until the court hearing pulls up. And then when court starts, they do court and then they can go back to working. So granted, that's not in the control of counties or probation, that is the judicial branch. But we are hopeful that they will expand the use of some virtual court technology.
Ms. Stark, could I just interrupt? Senator Ingebrigtsen, I see that you have your hand up, but could you hold your question until Ms. Stark finishes her presentation?
I will. Thank you very much, Mr. Chair.
All right, and we'll call on you first. Ms. Stark, please go ahead.
Well, your timing is impeccable, Mr. Chair. That was the end of my part of the presentation. With me today, I have Jim Schneider, who is the president of the Minnesota Association of County Probation Officers and also the director of Cass County Probation Department, and Travis Granzi, he's the president of MACAC and the director of DFO Community Corrections.
Right.
So they are here to answer questions as well.
All right. Well, Ms. Stark, I'm going to pause and let Senator Ingebrigtsen ask a question. And now, does Mr. Schneider or Mr. Granzi, do they have a presentation as well?
I would defer to them, Mr. Chair.
All right. Well, let's go to Senator Ingebrigtsen first.
Thank you, Mr. Chair. The question that I have is, has there ever been a statewide study, or has there been any discussions statewide for one delivery system for all 87 counties? Probably that question has been asked before, but is there any talk of that? And what do you think the cost, the overall cost to the taxpayer would be affected if it was a one delivery system statewide versus 3 different systems? Can you comment on that?
Ms. Stark.
Chair Limmer, Senator Ingebrigtsen, that's a wonderful question. I can't say that there's been a lot of discussion lately about one system, but we have been talking about whether changes need to be made. AMC and MACAC, and I believe MACPO, support something called the Justice Reinvestment Initiative by the Council of State Governments. It's where they would come in and look at public safety data and tell us where we are as far as return on investment and if we're getting the biggest bang for our buck or if we could make changes. And that's it's an effort where you would have to have the Senate and the House, the Chief Justice and the governor all agree to do it, and they would provide recommendations for possible changes. So there's been a lot of discussion about that project and about the fact that now is a good time to look at whether we are getting the return on investment that we need, because there's a budget deficit and there's some inequity between the three systems as far as who gets funded year to year.
Sure. Well, thank you for that. And that gives me a good question to ask the Supreme Court Justice. I think she's coming in to visit with, well, I'm not coming in, but I'll be visiting virtually with her next week. Also, do you have any statistics? Thank you, Mr. Chair, for the follow-up. Do you have any idea what neighboring states do? I guess that would be also part of a study. Now, I don't know that we can compare with North Dakota, South Dakota, or Wisconsin. We do that comparison in a lot of different areas of government, but do you know any of those and which ones work the best, do you think?
Ms. Stark.
Mr. Chair, Senator Ingebrigtsen, I think my probation directors might know more about that than I do. I know Kansas has a similar system as us, but and I think Wisconsin has one system, but I don't know if it's state or locally run.
All right. Mr. Schneider, would you want to weigh in on this? And would you identify yourself for the record before you answer?
Thank you, Chair Limmer. Good afternoon, everybody. My name is Jim Schneider. As Carly indicated, I'm the Director of Probation up here in Cass County, and I'm currently serving as the President of the Minnesota Association of County Probation Officers. Chair Limmer and committee, we really want to thank you for this opportunity to talk about field services. From an editorial standpoint, for years, we talk about the criminal justice system. A lot of focus does become on prisons, rightly so, but there's that other population that Carly had referred to, or Ms. Stark, at 103 people that are on supervision across the state. And we take pride in what we do within supervision. So having us be allowed to present today really enhances that. As far as the delivery systems conversation, Chair Limmer and Senator Ingebrigtsen, that conversation's been going on as long as I've been in the field, which has been close to 30 years. CPO counties really got established back in 1959 because it was this connection between judges and probation departments to be really nimble in how we work with people in the counties that we serve. But more importantly, it was talked about our juvenile justice systems because we knew early on in the systems that, if we could work with kids in what's known in Minnesota as a rehabilitative system. And I just want to emphasize that that's what our juvenile code is all about, a rehabilitative system that we know that we wouldn't pass kids up to the adult system and wouldn't have these collateral consequences and allowing kids to be kids, okay? And then working with them, working with communities. So that question regarding the delivery systems and across the board, we're one of few states in the nation that have a 3-model tier system. I know there are other systems that are out there that have dual models. Sometimes juvenile justice or juvenile probation is handled under the health and human services field, and then adults are handled within a one system model. So that conversation, and I just want to emphasize the point is that the council state government is really an important avenue for all branches of government to get invested in this process. We've been meeting with the Department of Corrections and Community Correction Act counties, and we've been having very healthy dialogue. And not even emphasizing the importance of a budget shortfall, but let's talk about when there's been budget surpluses, because equally we want to reinvest things to make things more efficient and have positive outcomes. Chair, I'll turn it back to you.
I think
You're
you're,
on mute.
Mr. Chair, I think you're muted yet. So
Senator Bingham always finds great amusement when I can't find the mute button.
can I follow up with one final question?
Sure.
Yeah.
Go ahead.
Sure, thank you. So in your conversations, and I'm sure you've traveled to other states over the many years you've been involved, do you think the three-tier system is kind of looked upon as one of the better systems then? Is that what you're saying? Or do you feel that a single delivery system would be better? And I'll end with that. Thank you.
So, Chair Limmer, Senator Engelbretson, we are quite comfortable with our delivery systems that are operating in the state of Minnesota. As Ms. Stark indicated, we're all focused on the same outcome with having local desires and needs about how we want to facilitate the criminal justice system. So we are in the business of not duplicating services, because I think that's one of the biggest key components to this, is that are you duplicating what you're doing? And we say, no, we're not duplicating that. One system takes a study, and then what system would that be? And maybe Senator Engelbretson, Chair Limmer, I would turn that over to Mr. Gansey down in DFO to maybe expand on that.
Mr. Gansey, yeah. Any thoughts that you'd like to add?
Yes, Chair Limmer. Thank you for having me today and for having us for this discussion. My name is Travis Gansey, and I am the Director of Dodge, Fillmore, and Olmsted County Probation down in the southeast of Minnesota. Just a couple of things to add. I appreciate the question, Senator Engelbretson. I think it's a good one, and I do think that there are things to explore here. I think one of the things that Minnesota prides itself on is the ability to give counties choice. That being said, having three systems within one state does create some challenges from time to time. And I think some of those are highlighted right now as we're talking about some of the budget shortfalls that we're all forced to deal with. And when those budget challenges hit, or even when the surpluses hit, as Mr. Schneider had pointed out, we need to find a way to make sure that both the cuts and the increases are delivered in an equitable way they can have the biggest impact. So I think there are a lot of other systems, Senator Engelbretson, across this country, and really, maybe short of Kansas, none of them really look like ours, and maybe don't have some of the complexities that ours have. There are also a number of states that don't have the Department of Corrections that oversees everything. Maybe in some states, the Department of Corrections has a responsibility for institutions, and there's another department that has responsibility for community supervision. So, and we could go on and on about the list of options and the way the different states do things. But, and I hate to almost mention this again, but I also believe very firmly in the idea that if we brought in the Council on State Governments to assist us in a justice reinvestment initiative, these are the very questions that they would try to assist us as a state in answering, to make sure that we are getting the best return on investment that we possibly could on the dollars that are appropriated from the state and the counties, frankly. So thank you.
Thank you for the answer.
Thank you. Senator Kiffmeyer, question?
Yes, I do, Mr. Chair. And probably just to make a comment quickly on the previous discussion, our form of government is very distributed, and I think that's a healthy thing. So from federal to state to county, city, township, and variations like that. And I just want to say, no matter what kind of system, yeah, you have challenges. Governing is challenging, and it's okay. But I think having individual portions of government. And I think when I see how the Department of Corrections and Community Services and other things, the big thing is when you do it to make sure you have. Investing, I don't know, is a word that I think of in regards to this, but I think having the Council of State Governments come in, I don't know, that'd be good use of what we want to do right now. But my question has to do more with the fact over the last probably 6, 7, 8 months, because of COVID, there has been change in regards to revoking offenders who have technical violations, and then we have these remote hearings and things like this. So that has really changed a little bit, Ms. Stark, on what you are doing. So what are the results? Are you seeing people who are, because bail is so low that they're not showing up, or maybe if bail is so low, but with remote hearings, they still show up? So can you give us a lay of the land and how that has interacted with the county services or Department of Corrections contract? Could you just give a broader look at that, Mr. Chairman?
Ms. Stark.
Thank you, Chair Limmer and Senator Kiffmeyer. I think I'm going to defer to the experts on this one and see if Mr. Granzi and Mr. Schneider would like to answer that.
All right, Mr. Schneider, would you like to handle that?
I can tackle the first part, Chair Limmer. So when it comes to remote hearings for pretrial stuff, for court hearings in general, we found that to be positive outcomes for people showing up. And what they're doing is basically taking their smartphone and being able to log into the hearing for non-contested hearings. And Ms. Stark had indicated that in the presentation. So for some counties, Cass in particular, we work with pretrial folks. And so what we're trying to do is to have 2 objectives, which is number 1, show up for court when you're supposed to through video means, or come to the courthouse through video means. And the second thing is not being arrested during the time you're in a pretrial status. So those are our 2 objectives with that. So we find that to be positive. We're not seeing more warrants that are coming out, at least locally, for the remote access.
Senator Kiffmeyer, you still have your hand up?
No, I'll take it
Another
down,
question?
Mr. Chair, but I'm not confident. I'm just kind of one of those that I'm not sure. But I think we're on limited time, Mr. Chair, and that's sufficient for now. I'll continue to pay attention since I'm a new member of your committee.
All right. Senator Bigham.
Thank you, Mr. Chair. I really appreciated, well, one, I agree with Senator Kiffmeyer, so let the record show that we have a very dispersed government, and I do think that is very healthy, and I think it heeds local control, which gets me to Senator Ingebrigtsen's comment, which I also appreciate. So, really it's up to each county board and how they want to deliver this service. And I think you see with Mr. Granzi, who has 3 counties, and those boards have decided to partner up and save money. Some counties obviously have more services that are needed than others. And so they have to, accordingly meet that demand and that service for their residents and for the folks that need the correctional services. So I think it would be a wise decision at some point to look at a baseline of services that would be provided. I think that is a healthy discussion for us to have at some point, Mr. Chair. And then I think you can have counties meet expectations or at least they know what to expect, and then they can kind of decide on their own what model works. The final thing I will say for you, Mr. Chair, which your screen went black, and Senator
Right now,
Andrew Matthews, Matt Johnson, and I can help out, with the technology sometimes. That was a joke, but anyway. So my question for you, Mr. Chair, is that we have a 3, option system here with CPO, CCA, and DOC, but we're only hearing from CPO and CCA. And I was just wondering if there's a reason. Are we going to hear from the department? I know we had an overview before of the COVID stuff, but we didn't touch on this delivery system. So I'm wondering if at some point we're going to hear from them as well, Mr. Chair.
I'm sure we'll have an opportunity to bring them in. The Department of Corrections will come and go numerous times. So we just thought that we'd group them together when they come in. Senator Latz.
Thank you, Mr. Chair. First comment I'd like to make is that although you may believe that Senator Bingham finds it amusing when you can't find your button to unmute yourself, I find it amusing when you do find your button and unmute yourself.
Was there a question in there, Senator Latz?
No, no, I'm not tossing it back to the chair on that one.
And I've got it on record, so I know everyone who's laughing and being entertained by Senator Latz's attempt at humor. Go ahead, Senator Latz.
Thank you. I did have a follow-up comment, which is to the point that while we are often very proud of our devolved system of government with a lot of local control, we have failed miserably as a state level entity in providing the resources that have been promised by the state to the local governments to do the state's work on our behalf. You know, at some point we have to stop utilizing the excuse that we simply don't have the resources at the state level to do so. And instead find the resources to do so. And that doesn't necessarily have to come at the expense of other priorities. We as a state have adequate resources to do what we think is important to do, should we choose to bring those resources into the state government for redistribution to the services that we are delivering. You know, our probation officers are constantly laboring under an excessive workload, an excessive caseload, cannot do the kind of job that they should be able to do, that they could do, if they had enough resources to distribute some of that caseload among a few more officers and then give the time necessary to the probationers that really need that additional time to be successful while they're in the community. It's a lot more expensive, and we've heard this from the DOC directly too. It's a lot more expensive to have someone fail on probation, violate, and be returned to prison. I don't remember what the actual numbers are, but if I recall, somewhere around 20% or so of our state prison system is populated by releasees who failed and were returned for one reason or another. And if we believe that our system of probation is effective in what it does in any way, shape, or form, we have to believe that more resources, fewer cases, and greater ability for the probation officers to spend the time on the high need probationers, high risk probationers, would result in fewer readmits to the state prison system, which sometimes are technical in nature, but sometimes are more serious in nature. And certainly when they're more serious in nature, it would result in fewer negative impacts on the local communities as well. So I would hope that as we put our budget together this year, that we consider not only the resources that are already scheduled to flow into the state coffers, but also whether it's worth it to find additional resources so that we can make the investments here that will save us money and save our communities harm down the road.
Thank you, Senator Latz. You know, Senator Latz, you and I have agreed on the commitment to probation costs by counties off and on over the years when the debate arises. I think we've got a little ways to go. First, we have to see what kind of budget projections we get in February, at least this year. But then at the same time, I couldn't help but notice that the governor's budget is cutting probation costs, our budget, by $8.3 million across the state. So we have a little educating to do. And I certainly sympathize with the counties and their probation costs and the promise that was made earlier, many years ago, to absorb at least 50% of some of these costs. So the issue is not off our radar screen yet, but thank you for bringing that up. Appreciate it. Any other questions? I think since Senator Latz, did you want to keep asking a question? Your hand still is up.
No, Mr. Chairman, I don't have a follow-up question.
All right. I think we'll move on to the next area. Unless someone has any other questions. Does anyone have any other questions for our guests here? We're waiting for Commissioner Lucero to arrive. So we're desperate for questions for our guests.
May I make a clarification about the governor's budget?
Yes. Yes, Ms. Stark.
Thank you. So it is accurate to say that in fiscal year 2023 that community services is cut, but in fiscal year 22, only the county systems and pass-through subsidies were cut. DOC field services was not.
Okay. All right. Well, that's good to know. Thank you for that. Any further questions? I have been told that Commissioner Lucero is on or in our video presence right now. And so Ms. Stark, Mr. Granzi, Mr. Schneider, thank you so much for your time and the information you provided. Thank you again. We'll be moving on to Commissioner Lucero and her report regarding the Department of Human Rights and an overview. Commissioner Lucero, are you on our screen?
Yes, I'm here. Can you see me and hear me?
Yes, I can. I can hear and see you.
Wonderful. Thank you. Thank you, Chairwoman. And thank you so much for a little bit of flexibility. I was running from a community meeting to here. So I appreciate the time, folks. Let me start by sharing my screen with everyone. And let's see, this is it right here. So I'm hoping you'll be able to see this pop up. And some of you have seen a presentation like this similarly, and I'm hoping that might prompt additional questions. For those of you who I have not presented in front of in this committee, welcome. It's an honor to be here with you all today. And I'm just going to talk about what our agency does. So first off, a little bit about myself. I am an attorney who practiced at Legal Aid doing consumer protections work. I worked in private practice as an employment lawyer and as an administrative law judge for deed. About a decade ago, I focused my work in public policy. Most recently, I worked at the Twin Cities Habitat for Humanity and at the Minnesota Council of Nonprofits as the public policy director, working to support the thousands of nonprofits across the state. So this is the perfect combination of my legal and my policy work coming together, and I'm honored to do this work every day with the team. Also joining us today is Eric Armankonki. Many of you, if not all of you, know him. He's the Government Relations Director. Before joining the agency in 2019, he worked with the Children's Defense Fund. Now, the Minnesota Department of Human Rights is proud to be Minnesota's civil rights enforcement agency. The department's mission is to make Minnesota discrimination-free so that residents can lead lives full of dignity and joy. Our work is essential to protecting the civil rights of Minnesotans, particularly as the state's communities grow older and there's increased concern with age discrimination and the population becomes more racially diverse. Our work remains essential. Let me tell you the 3 fun facts about our agency. We have 45 employees. We are a small but mighty team. Our biennium budget is $10 million. And we do our work in every single county across Minnesota. Now, the Minnesota Human Rights Act is the foundation of the department's work. The act passed into law in 1967, and as we mentioned, it protects the civil rights of every single Minnesotan. There are 3 areas that we are responsible for enforcement under the Human Rights Act. This is investigating charges of discrimination. That's what we're most known for. Next is the equity and inclusion for state contracting. And the third area is the education and outreach work that's done to support landlords, business owners, and community members to reduce discrimination altogether. So I'll talk about each one of these specifically. So the Act tasks the department with important enforcement duties in employment and housing and education. Those are the most common, but other places as well, such as public accommodations and public services. And this is based on protected classes such as race, religion, disability, national origin, sex, marital status, familial status, etc., age. The most common type of discrimination cases overall are employment cases. By far and away, employment represents the vast majority of the cases that we see. There are also some housing cases and school cases, but employment is the largest. Where we see the most common basis for discrimination is actually in disability. Disability is the area where we see the most charges of discrimination come in. We also see a lot of sex discrimination and race discrimination, but by far and away, disability is where we see the most. So let me just talk you through, because we get a lot of questions of, okay, but what happens if I file a charge of discrimination with your agency? Who do I talk to? What are the decision points that are made? So we have this flow chart. It's up on our website, and it goes through all the processes for anyone who might be wondering. So if somebody calls our office and says, hey, I think I'm facing discrimination, and I'd like to know if this is something that you guys can maybe help with. Now, first, an investigator will look at whether or not it's covered, or if it's not covered, we are tracking bias incidents for outreach and education opportunities. Think of something that's not covered, but we would want to track. A good example of this is maybe a swastika that's been painted on my garage door. It's not covered by the Minnesota Human Rights Act, but it's certainly something we may want to be aware of and know. And if it is covered, we file a charge of discrimination, and that then goes to the respondent. Like I said earlier, typically an employer. Both the charging party and the respondent have an opportunity to participate in mediation. If they participate in mediation, they reach a resolution. That's great. That's great, and particularly because it's mutual decision resolution that they come to get together. And if they don't reach an agreement, it just goes back into the investigation. After our investigation is complete, we issue a determination of either no probable cause of discrimination or probable cause of discrimination. I'm going to talk through a couple examples of where we did issue a probable cause of discrimination. This is Laura. She's a vet. She has a service animal because of a service-related disability. The employer that she was working at refused to let her bring her service animal to work. We found discrimination in this case and worked to settle this case, requiring policy changes so that in the future, anyone who has a service animal would be able to use it at this place of business, as appropriate, of course. The next example is about a 16-year-old. She was raped by her supervisor. She's a lifeguard at a beach, that she was working at. The supervisor even drove her to in the county vehicle to purchase Plan B emergency contraceptives. The lifeguard that was sexually assaulted immediately reported it, not to one, but to two supervisors, and neither supervisor took any action. A year later, when she was back and again assigned to work with that same lifeguard who had assaulted her, she reported it to now a third supervisor. It was finally that third supervisor who acted. So the settlement agreement really requires, in this case, a county to update its policies, provide training, make sure that sexual harassment concerns are addressed promptly after they were reported, and to provide that training, like I mentioned, to all lifeguards. The next area that we do our work is in the state contracting. The Act tasks the department with regulating state contractors to ensure men and women are compensated equally for equal work, and to ensure that contractors are making good faith effort to maintain inclusive and equitable forces so that the company's employees reflect Minnesota's vibrant communities. One great example of this work is the partnership between our department and J.E. Dunn on the Capital Restoration Project. It's one of the largest recent construction projects in Minnesota. And on the project, the company actually exceeded the workforce participation goals with 35% people of color and 21% for women. Now, how they did this, they partnered with local nonprofits to bring more people of color and women into the industry. And what's important, and I think most exciting to me about this, is that J.E. Dunn was able to keep those employees beyond the project. So more than 80% are still in the trades today. So this state project did more than renovate a historic building. It helped bring historically disenfranchised communities into well-paying careers. So, being intentional matters. It makes a difference. Yep, and as I mentioned, we also ensure that employers are paying men and women the same rate for the same job as part of the equity inclusion work. The last area of our work under the statute is really the education work. And we collaborate with individuals, communities, employers, et cetera, across the state. One group that we spend a lot of time collaborating with or talking to is the Human Rights Commissions that are in many cities and towns across Minnesota, maybe in one of yours, and we work with them regularly. Some other additional work that we have is we have Ban the Box for private employers, and then some interagency work, Children's Cabinet, a couple that have to do with housing, Olmsted, and then the community resiliency and recovery work, which had to do with COVID, which is a perfect transition into talking about COVID. I am happy to report that we were able to move very quickly into whatever this new reality is. And so no Minnesotans should have felt too much of an effect with our agency moving into kind of a more virtual world that we are right now. So our COVID work is that we continue to do the work that we do every single day. Where we see the most issues related to COVID has to do with disability. And that has to do with employees calling and saying, hey, I need a reasonable accommodation. I'm happy to report that employers and employees have taken this opportunity to really rethink and be very flexible and creative about what a reasonable accommodation could be so that folks can continue to do their work and provide for their families every single day. And of course, we continue to investigate our charges of discrimination. We also have some policy changes to provide some technical flexibilities. This is for charging parties and respondents. And that includes something like, first and foremost, the ability for charging parties and respondents who want to communicate with us via email. That is something that in certain places they weren't able to under statute. That transition has been well received. The second is additional time for a respondent to reply for a charge of discrimination. And third is additional time for charging parties that respond to file an appeal. We've received a lot of feedback that this is going well. Employers have really appreciated the additional time to respond. Under statute, it's 20 days. And this gave them a little bit more time to get information when they didn't have the files. They weren't even in the office. They were trying to figure out how to get people and keep them safe. So I'm happy to report that that's going forward. I know we're all really anxious for COVID to end. Once COVID is over, I'm very excited about it. There shouldn't be anything that's felt by Minnesotans as we transition back. So thank you very much for your time, and I will stop sharing so we can see each other, and I stand for any questions.
All right. Thank you, Senator, I'm sorry to demote you, Commissioner. Commissioner, we'll take questions. Senator Ingebrigtsen.
Thank you, Mr. Chair, and thank you, Commissioner, for the very fine, quick, and concise report. I have a question. Let's back up to the 80% of the minorities that were kept on by that employer. Can you repeat what you said about that? Was that a local employer? Obviously, it was a very successful program, or was it a program that was suggested?
Commissioner Lucero, you're on mute. No, you're not. Okay.
Thank you, Chair. Thank you, Senator Ingebrigtsen. So J.E. Dunn, it was the contractor for that project. And I want to find exactly what I said, so I make sure I get this correctly. It said that on project, they exceeded the workforce participation goals with 35% for people of color and 21% for women. And of those, 80% of those folks are still in trades today. And you are right that the way they were able to do that is because of really smart partnerships with local nonprofits. And I would have to circle back to you on what those nonprofits are, but it was intentional to bring more community members into the industry.
Well, that's a wonderful program.
Senator Ingebrigtsen.
Thank you, Mr. Chair. That's a wonderful, wonderful outcome there that basically was community-based and not mandated, I would assume. But I guess the second question is, how many cases does your office handle a year with regards to pay equity or any type of real discrimination where someone of a minority walks into a business and is told, because of who you are, I'm not going to hire you? Are there a lot of cases like that?
Commissioner Lucero.
Yeah. Thank you, Chair. Thank you, Senator Ingebrigtsen, for the question. So we certainly have examples of kind of direct discrimination that pop up. I'm going to have to circle back to you on a couple on like clear examples. I don't have a number for you on that today. I would say that is oftentimes the case with discrimination. It's a little bit more nuanced than that. Like, for instance, the vet who was hired but wasn't able to use her dog, and so her service animal. And so let me get back to you on some specific
I would love to have
examples.
that discussion. That'd be great. Thank you very much.
Any other questions for the commissioner? Commissioner, I had a question. In the area of state-funded projects, some of our counties in outstate areas are rather low populated, and they may not have, from a demographic perspective, enough people to satisfy particular racial requirements, or a polished or a resume with the skill and education background to satisfy the particular job placement. What happens with a corporation that just can't find the people in a remote, low populated county, let's say? Would they be in violation of human rights ruling? I think a number of people have asked me that question, and maybe you could expand on that for me.
That is a great question. And so first and foremost, we want to be really clear that these are goals. They are not quotas. So we're looking for good faith effort to achieve this. And what is good faith in one community is going to be different than good faith in another community, being what's going on there. Sorry, I feel like there's a lot of noise in the background up here. Oops. Sorry. Secondly, can you hear me, Chair?
Yes.
Perfect.
I'm still hearing a little side noise, but go ahead.
Okay, and then second, the workforce goals in Greater Minnesota are different than they are for the Twin Cities. We work really closely with contractors to help them see where they can achieve these goals. For instance, J.E. Dunn, we were working with, and so that's how we will continue to make sure that the goals, and we partner with them, not quotas.
All right. Senator Kiffmeyer.
Thank you, Mr. Chair. I heard the statement made that from Commissioner Lucero that communities look at things differently. Could you explain a little bit more about how that would be the case?
Commissioner Lucero.
Thank you, Senator Kiffmeyer. I apologize. I'm struggling to understand the context that I said that, and so I'm not sure what the. Can you just provide me a little bit more context?
Senator Kiffmeyer.
Thank you, Mr. Chair. Well, as one of your last statements, it was in that context, and you just said that something about communities looking at things differently. And so that struck me, and I just want to know what you meant about different communities looking at things differently, what that might be. if that's helpful.
Sarah Kiffmeyer, was that in reference, or was that an answer to my question of if there's demographically a difficulty in achieving the goals of employment in a balanced, inclusive manner? I think the commissioner said that first, their goals, and second, that every county may be a little different in its demographic workup, and that they have to recognize at least the demographic lay of the land that they're dealing with. Commissioner Lucero, would you want to?
That was it, Mr. Chair. That was it when it started out with that conversation. Yes, thank you.
Commissioner Lucero?
Perfect. Thank you. Thank you, Senator Kiffmeyer. I mean, I think that what I meant to say is that good faith effort for one community is different than good faith effort for another community, because we recognize that every community is different, that like their regional goals for each.
All right. Sarah,
Well, thank you, Mr. Chair. I'm still a little bit interested in that, but if you'd like to go on, we can discuss this further another time. Thank you.
Sure. Are there any other questions for the commissioner? I do not see anyone's hands up. Going once, going twice. We're about ready to close then. Commissioner Lucero, thank you for the presentation. I enjoyed the presentation. It revealed a few things that I had a few questions on, and I want to thank you for that. Just for the record, Commissioner Lucero and I had a conversation a few days ago and talked about, certainly the Department of Human Rights and the legislative season. And so I'm sure we'll be talking even more throughout the session. So thank you, Commissioner Lucero, for being our guest today. And with that, there's no other business before the committee. We stand adjourned. Thank you.